Are you Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court and entered pleas of true to counts 1, 2, 3, 5, 6, 8, 9, and 10 in a motion to revoke his probation. He's on probation for driving while intoxicated third or more. This was unagreed. I've received the updated pre-sentence report. Have you both had an opportunity to review that report?
You have, Your Honor.
Judge. Any additions or corrections to the report?
None more, Judge.
Mr. Parker?
Judge, I mean, my intention, excuse me, was that, and what Ms. Malfina and I talked about is that he had some serious health conditions. He ended up using drugs. I don't know how long he had been using drugs in the past. He and I had a heart-to-heart talk, explaining the situation he's in, and we talked about SAFP being a great option for him. Now, his mind has changed, and I like to let him address the court, but he said being in jail, he's been in there for a while now. He said his mind's clear, and he was here before on oxygen, and he's able to breathe better with his emphysema and all the other issues that he's had. But he's indicated he just wants to take his time. And I mean, my position is I personally think safety is probably the best thing for him. But at the same time, if he doesn't want it and then why take him to bed? Ms. Bells could use it. I'd like to let him address the court, Judge.
So, Mr. Hebert, the recommendation was for potentially SAFP and to get you that help. Are you saying you don't want that?
I'd like to just go back to probation and get help from home.
Well, that's not gonna
That's
happen.
okay.
Yeah, so it's either SAFP or prison.
Safety. Yes, ma'am.
So here's the thing about SAFP. It's an expensive program. And I don't want you to, kind of like what Mr. Parker said, go just take up a bed and we pay $70,000, $80,000 for you to go and you don't get what you need out of it. If you don't go in with the right mindset, then it's going to be a waste of everyone's time. If you want that help, I'm willing to give it to you.
Yes, ma'am. Please.
Ms. Malfino?
And if I may respond one other thing, I think part of his attitude was when he did the PSI is that he was like, I'm on drugs. And I think maybe now that he's been there, he's cleaned up a little bit and not on drugs and realized that the help, he really needs that. And
I mean, you
That's why
tested
it's
positive 1 month after having an angioplasty and a stent. You started using drugs again. So obviously you need some help
Yes, ma'am.
if you're doing that 1 month after that kind of scare. So,
Yes, ma'am.
Ms. Malfino, anything to add?
No.
So, Mr. Hebert, I'm going to give you this opportunity and I hope you take advantage of it. I'm going to find that you entered your pleas of true, freely and voluntarily, find all of those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. Let's see, you were put on in September 25. I'm going to order that, as a condition of your probation, you enter and successfully complete the safety program. If there are still ongoing medical needs, then they'll put you in the special needs safety to make sure that any of that's taken care of as well. So I'll let them determine which one, but it probably would be the special needs if you're still having some ongoing health issues. This is your opportunity to get clean, live the rest of your life, finish your probation, and not go to prison.
I appreciate it. Thank
You're
you.
not going to get an opportunity like this again, so take advantage of it.
Yes, ma'am.
So this was not an agreement. So I'm going to hand you the trial court certification. You have some rights to appeal. Can't imagine that you would since I just did what you asked me to do, but here is, if y'all will sign the bottom and then just give him the bottom. Brent Smith,
Thank you, Judge.
are you Howard Dwayne Walker Jr.?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
It will, Your Honor.
Mr. Walker, in clause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. DeLage?
Yes.
Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Walker's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of injury to a child. Sentence you in accordance with your agreement to a term of 22 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. DeLage. And Ms. DeLage, do you have your discovery certification?
The cert, I don't have the discovery sheet yet. I was going to email it this afternoon. Didn't expect to get a plea today.
Yeah, if you'll get that done as quickly as
Yes.
possible, and because the case has to get closed out,
Right.
then it becomes, you won't be able to get to it.
Yes, ma'am.
Okay, you can go back with the bailiff.
Thank you.
Do you want to make these?
But that's what's alleged is that and how.
Thank you.
Thank you,
And
Nancy.
may I excused?
Yes, thank you. Good morning. Are you Gabriel Cruz III?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment in each case?
0373 and 0374.
Mr. Cruz, in cause number 26 DCCR 0373, you're charged with a 3rd-degree felony offense of stalking from February 23rd of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
And then in cause number 26 DCCR 0374, you're charged with the 3rd-degree felony offense of violating a protective or bond order, and that's from February 23rd of 2026. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily?
Yes,
And because you did what they charged you with? I have here on the tablet in each of those cases some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yep.
And it looks like the agreements that you've reached are for 10-year term in prison on each of these cases, but that would be probated for 10 years. There would be a $500 fine in each case. There would be a dismissal in cause number 26 DCCR 1060, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
This courtroom moment captures a powerful turning point when justice meets opportunity. The defendant stood at a crossroads facing the reality of prison after repeated poor decisions, but instead of immediate punishment, the judge offered something rare, a final chance through rehabilitation. It wasn't sympathy, it was accountability with a purpose. The judge made it clear that without the right mindset, even this opportunity could be wasted. That's what makes this moment so compelling. It's not just about the law, it's about whether someone is truly ready to change. In the end, the decision wasn't just the judge's, it was his. And now his future depends entirely on what he does next.